It's just, you lose in society your respect by having the social stigmas, the ability to find a job, to work, to earn an income, to support your family if you had one, but I don't have a family. I have no children. I lost all of that. I lost friends. I had fallen out with family. I lost the ability to see nieces and nephews of mine that have been born. When I was confined, I had 2 nieces. Today, right now, I have 16 nieces and 17 grandnieces and nephews. I have nieces and nephews I've never met. Never. And they're in their 30s. I've never met them. I wouldn't know them if they walked through the door. I wouldn't know them. I have to just deal with it as it is. I can't ask my nieces and nephews to be reborn again. You lose the ability to have the choice to do certain things because of the constraints that you have by being a felon, being on parole. It's just a lot of things you can't get back. A lot of things you can't get back. Hopes, dreams, you can't get it back. You lose it all. You lose it all.
Today, we will be speaking with Robert Allen. He was released in 2009 after serving 30 years on a life sentence for aggravated kidnapping and sexual assault. He proclaims to be innocent, and he's striving to clear his name. He wants to be vindicated, and he's willing to spend the rest of his days to prove his innocence.
Why tell my story? I didn't do this crime. I didn't do it. But my primary concern is, I want to clear my name. I want to clear my name. Well, my life changed on September the 15th, 1979, because that is the day that I actually got arrested. At the time I got arrested, I just got out the active military, so I was in the Army Reserves. I was working as a private duty male nurse. And I was going to pre-med school because my goal in life was to be a pediatrician. I was originally arrested for suspicion of murder, attempted capital murder. They tried to put the robbery case on me, and then 5 days after I was in the county jail on those crimes, those offenses, then this is when they came and rebooked me and said, okay, now we're charging you with an aggravated kidnapping case. I'm like, aggravated kidnapping case. So the only thing I knew about that was originally was that the federal government had got into it because it was crossing state lines. They alleged that I kidnapped a woman in El Paso, Texas, and we drove all the way to Alamogordo, New Mexico. So from my understanding, again, I didn't see any paperwork, just what I was told word of mouth was that the federal government looked at it because it's crossing state lines, so therefore interstate commerce comes into effect. So they looked at it, from my understanding, they were like, no, this is some BS. It's not even the case. So they dropped it. So how I actually got the kidnapping case was because the state of Texas picked the charges up, because the crime, as they alleged, started in Texas and ended in New Mexico. And in that case, it was supposedly, from her testimony, her police report, it was myself and 4 other men who were assisting me. But I was the only one that got arrested and indicted. The other 4 people, they never indicted anybody, they never interviewed anybody, they never arrested anybody. But the problem with that was, when my trial started, they alleged another individual named Ron. So instead of it being me and 4 individuals, it became me and 5 other individuals. But again, I was the only one got arrested and indicted. Well, the day of my trial, the courtroom was actually packed. All the seats were taken. They even had people standing on the wall, which I thought that was unusual. To me, it was more, as I later on in years, I said, was it really a trial? Was it a public spectacle? Initially, where I got actually excited and the shock actually came off to me was the first person they called was the complaining witness. And when she walked in the courtroom, she actually stopped, waved at me, and smiled at me, and told me good morning. Like, well, good morning, how are you doing? She said, oh, I'm doing just fine. So my attorney, she told him the same thing. Good morning, how you doing? He said, I'm just fine. So I reached under the table and I pulled his coattail. I was like, Mr. Hill, I said, she don't even know she's supposed to come in here and identify me. He said, don't worry about it, I got it. So she testified approximately 2 hours. But after about an hour and a half of her testimony, they put 4 pictures in front of her and asked her if she looked at these pictures to identify me. She said, yes. So they asked her, the DA asked her, Mr. Moody, he said, well, do you see the defendant's picture in there? She pointed to the 3rd picture. She said, oh, yes. That's Robert's picture right there, the 3rd one. So he acted surprised. Oh, you know his name? She said, well, I didn't know it then, but I know it now. So I'm thinking to myself, here it is, you're sitting here, you wave at me, smile at me, tell me good morning. 97 days after you alleged I kidnapped you and sexually assaulted you, to me that doesn't make sense. Psychologically, not even rationally. But then an hour and a half later, you look at me and identify my picture, but it's quite natural. You've been sitting there looking at me for an hour and 45 minutes. How the whole saga started, she was at home. She said she got a phone call for her brother to go pick this young lady up, was at a disco. She tells the young lady, my brother's sleeping, I'll come get you. So she gets dressed. Now you gotta mind, she had on a dress, stockings, shoes, jewelry, everything. Well, what were you doing prior to this phone call? Oh, my father was in the hospital, so I was at home cleaning the house. So who gets dressed up like that just to go to a parking lot to pick somebody up? So basically, she said when she drove up in the parking lot, that's when I run up on her before she got out the car and put a gun in the face and told her, bitch, get back in the car. She locked the door, said I walked around the car. She reached over and unlocked the door and let me in. We ride from El Paso to Albuquerque, New Mexico. That's approximately 100 miles. I have a car with 4 gentlemen who are following me. We stopped on 2 occasions. I got out and went and talked to these 4 men that are behind me. So she was asked, at that time, could you have drove off? She said, yes, I could have. So my attorney asked her, why didn't you? She said, well, he had a gun. I thought he'd shoot through the window and try to kill me. After she said I released her, 2 of the guys who were with me took her car and drove off. She said, I stayed with her. Then they came back. She said, I hit her in the head and she fell to the ground and pretended like she was knocked out, and I run off and got in the car with the other individuals who was following me. What she did was she was on the highway. She said she was hiding in the mesquite bushes in the barbed wire along the fence. She said every time a car came by, she would duck down and hide in the bushes because she thought we was going to come back to kill her. Because previously we was in a huddle talking, as she said, and we was talking about killing her, and she said she heard somebody say, let's listen to what Ron has to say. So that adds another person to the story. Instead of me and 4 people, now it makes me and 5 people. So as these cars were coming, she was hiding. So she said she saw approximately 7 cars coming. She jumps out on the highway, stops the car. There's 3 white males in the car. The white male in the driver's seat, the passenger seat, gets out and gets in the back. She gets in the front seat. She tells the driver, oh, I've just been raped. She said there was a body in the street, like there was an accident. The driver asked her, do you want us to take you over there to the ambulance, to the police? She told him no. So she said they made a U-turn, and these 3 men that she doesn't know drove her 95 miles back to El Paso, Texas. Now here's a woman who's just been sexually assaulted, beat up, and you get in a car with 3 men you don't even know. But yet you saying in your police report that there was a body in the street, like it was an accident, and there was some police and an ambulance there, and the driver asked you, do you want to go to the police and the ambulance? And you told him no? That doesn't make sense to me. It does not. So they drove 95 miles. They go to a phone booth. She calls her boyfriend. These 3 men stay with her approximately 1 hour. Her boyfriend shows up. The 3 men leave. But my question was, when you got back to El Paso, Instead of calling your boyfriend, why didn't you call the police? She never did. She chose to call her boyfriend. He picked her up, took her to Eastwood Hospital. She said they would not accept her at Eastwood Hospital. So she left Eastwood Hospital and drove 45 minutes to the west side of town and went to Sierra Medical Center. So after she testified and got off the stand, they called Dr. Robert Denishay. He was the doctor at Sierra Medical Center who did the actual physical examination, the sexual assault kit, the neurological exam, and all of that. And his basic testimony was that after doing the sexual assault kit, that he made 4 slides, he put 2 in the kit, and he said he took 2 slides and immediately took them to the lab and examined them. So in my mind, I'm thinking, well, why would he do that? Because he said that was something that he normally did not do. So to me, that equated with he had doubt as to her story, whether she was sexually assaulted or not. So his basic testimony was that when he examined the slides, he said he found no trace of sperm on the slides whatsoever. He basically said he could not say whether sexual intercourse happened or it did not happen. He just said he found no traces of sperm, but he also testified that they don't follow up on a lot of cases. So he said, we do see cases where women feign rape, which means that they make it up. He said, but we don't follow up on a lot of cases. He said, but the wet slides, they were negative. He said, I didn't see the sperm, they were negative. And you gotta remember, this is a state witness, but he's testifying in my behalf. And I think the fallacy in that is the state automatically thought he was gonna give testimony in their behalf, but he didn't. So as far as the defense, I gave him the name of 5 witnesses to call on my behalf. He did not call not one of them, not one. So basically, as far as my defense, there were no witnesses called for me at all. None. None whatsoever. Well, the actual trial was 8 hours. The actual jury deliberation was 1 hour and 51 minutes. So you're looking at a total of 9 hours and 51 minutes. Trial and jury deliberation, because my trial started at approximately 8 o'clock in the morning, and it was approximately 10 minutes to 7 o'clock p.m. when the jury actually returned the verdict, saying that they had found me guilty. Regarding the case in my first decade, I basically had to rely on my appellate attorney because I didn't have none of my trial records. So my appeal was filed. It took them 2 years, which on May the 8th, 82, they denied my appeal. So basically the appeals court is saying there was no errors in my conviction. I always knew that something was wrong, but not being familiar with the criminal justice system, the legal field, I was like, wait a minute, something's not right. You know, you just get that gut feeling. So my endeavor was, I'm going to the law library and I'm going to find out what happened. So I'm still in the book studying. Well, from reading the rules of appellate procedures in the state of Texas, I know I can't do anything sufficiently without my trial records. And in that first decade, up to 89, I attempted approximately 4 times to get my trial records. Anytime you file a brief, you have to make reference to the trial record. So when they say, okay, you said this happened, well, they can get your transcript and say, okay, he said on page so-and-so, line so-and-so, they can go and say, okay, it did happen there. So I couldn't rely on my memory, you see, because I can't make reference to the trial record if I don't have the trial record. So I knew in order for me to do what I needed to do and, quote, abide by the rules of appellate procedure, I had to have it. Because due process simply states what process is due. Said Judge Pena, every time he denied me, he would never give me an actual written order as to why he denied me. He would just say denied. I always got what they call the white card. Denied without a written order. What does that mean? That means simply that, see, we can deny you, but without a written order, we don't have to give you the legal reasoning as to why we did what we did. So in other words, they don't have to give you a finding of fact, conclusion of law. Basically, that's what they're saying. We're denying you, we're just not going to tell you legally why we did it. 4 times, from 79 to 89. The second half from 89 to 99, it was like 1995, I want to say. I get called to the mailroom. Got a package. Like, okay. It's a copy of my trial record. First year law students know, you always file a motion for your client. Motion for discovery, at least to discover what the state has or the prosecutor has in his file against you. Did my attorney do that? Of course he didn't. So there was no motions filed, period. Because see, if he doesn't file a motion for discovery, that means he did not know the facts and circumstances surrounding my case, number one. Number two is, if he doesn't know the facts and circumstances surrounding my case, then number two, he can't research the law in relation to those facts and circumstances. He don't know the facts and circumstances, he doesn't know the law in relation to him, and he doesn't know what adequate defense to raise for me. So when I got my trial records and I put the ineffective assistant counsel together, the affirmative finding that the judge did, the right denial of the right, all of this, I'm like, okay, yeah. I got the trial records, here it is. Here's where it's in the trial records. You can't show me anywhere in this trial record where he did anything for me, except made 2 objections. But when I shot that writ of habeas corpus challenging the constitutionality of my case, along came Judge Payne again. Bam, denied. Denied. But where did things open up for me in that decade? When my mother sent me that letter and told me, oh, guess what? Judge Payne, he got indicted by the Fed. Really? Oh, Gary Hill, my trial attorney? What? Scott Siegel, my appellate attorney? Bribery, extortion, income tax evasion, mail fraud, racketeering? Oh, yeah. So see, an actual hurdle was removed. Like I said, the first decade, 79 to 89, shot down, shot down, shot down. 89 to 99, when I finally got everything, I'm like, okay, now it's opening up. I got to make this last hardcore push. So I'm already at the end of my second decade. So now I said, you know what, it's time for me to do me. He started in 99 to 2009, and I got all the trial records now. Another thing opened up for me is when Governor Rick Perry signed the DNA statute in effect in 2001. So in 2001, I made a request. 2002, I made a request. I came back again in 2003. Finally, I get a response from the judge now that took over Judge Payne's court. So then I went to the 243rd District Court. They gave me Judge David C. Guadarrama. So when I went back on the DNA, Peter Bright was my attorney. He came to me with some mess. Well, you know, Mr. Allen, September 2005, you can have 26 years. Basically what he wanted me to allow him to do was to take me into court, let me change my not guilty plea to guilty, and they could give me time served. So I'm not doing it. I finally went January of 2006. I had a hearing on the 6th of January, 2006, the 13th of January, 2006. I had a hearing February the 3rd, February the 10th, and my last hearing was February the 23rd of 2006. And basically what happened was, you know, the state was like, oh, we need more time to find this, find this, find this. And basically what happened at the last hearing, they were saying that all my DNA evidence had been destroyed. And all they did was basically got an affidavit from Sergeant Eddie Smith stating that all evidence, including all biological evidence, had been destroyed. But the interesting thing was that they gave 5 different reasons why they couldn't bring the evidence. First, they said my stuff was destroyed in '84 because it met the 5-year record retention rate. I'm like, that's impossible. Texas Revised Civil Statute says you must keep a permanent record. Then they said, oh, well, everything was destroyed in 1999. We did these 4 boxes of evidence. But the lady from the archive put her on the stand. She said, no, there was no biological evidence in there. None. Got the one with DPS. Oh, well, we turned all that stuff back over to the district attorney's office. So how did you get an affidavit from the police department stating everything was destroyed? But the whole key was Mike Martinez. He was the custodian of evidence for the district clerk's office. Because at the conclusion of your trial, a court clerk is to take that evidence, transfer it to the district clerk's office so they can store it in their archives. But I have the transcription where he testified in my case specifically, my particular case, the court clerk never transferred the evidence from the court over to the district clerk's office to be held in the archives. So he said, so I don't know what happened to Mr. Allen's evidence. I don't know where it's at. It was never transferred over to us. Every procedure basically that they were supposed to go through, preservation of the evidence, all of this, they didn't abide by none of it. None of it. And what really upset me was, prior to me going back in 2005, Brandon Moon. He got convicted in '87, sexual assault on the University of Texas at El Paso. But 17 years later, in 2004, you have his DNA, he got exonerated by the Innocence Project in New York. And he got out December the 6th, 2004. So how is it that you preserved his DNA evidence for 17 years after his conviction, but you didn't preserve mine? What happened to equal protection? So why did you keep his evidence, but you didn't keep mine? That question has never been answered. The state having to actually put in writing why they could not bring the evidence to the court, they still have never done that. So they denied my DNA testing almost a year and a half after I applied, because when I found out about the destruction of the evidence, when I went back to my unit in April of 2006, I filed a motion for new trial based on the loss and destruction of the evidence. I came back a month and a half later and filed a supplemental motion for new trial. Because in 1990, see, the state of Texas ruled for the first time that DNA evidence was admissible in a criminal case. Well, if you're saying my evidence was destroyed in '99, then you knew 9 years prior to you destroying my evidence that this evidence was admissible in the case. So if it is the duty of the district attorney not to convict, but to see that justice is done, when you knew in '90 that my DNA evidence was admissible, why did you allow it to be destroyed 9 years later when it was clearly admissible? And if it is your duty not to convict, but to see that justice is done, why would you destroy something that had the potential to exonerate me? Why would you destroy it? The question was never asked, and it was never answered. Look at the fingerprints that they got off the car. They got 6 latent fingerprints off that woman's car that they said I rode in 100 miles. They got 2 partial palm prints off the trunk of the car. They got 3 partial palm prints off the same purse that she said I opened up and took her driver's license and told her, bitch, I see you ain't lying to me when I asked her where she lived. But they knew in September of '79, 3 months before I went to trial, that none of the fingerprints belonged to me. 36 years later, they still haven't told me who those fingerprints belong to. If it is your duty not to convict, but to see that justice is done, how come the state of Texas never took those fingerprints and run them through the AFIS system? So what does that mean? There's still an unidentified defendant out there. What do we know? We know beyond a reasonable doubt them fingerprints aren't mine. We know that, but this is the same car you said I rode in 100 miles. So why did I have to go through all these hurdles and obstacles just to get a ruling on a motion? Why did I have to go through all the hurdles and obstacles just to get my trial records to do what I needed to do? Why? Why? I did it because I had to do it. So everything I did that whole 30 years, I had to run the gamut. I had to jump through the hoops. I had to do this, I had to do that, but I did what I needed to do. So I came up for parole in 2009, March the 18th. From my understanding, 2 days later, they granted my parole, where it normally takes you 6 to 8 weeks to get it. I walked out in July 2nd, 2009. As far as the unanswered questions that I'm trying to get an answer to is, number one is just the basic evidence that they had. You have these fingerprints that you knew 3 months approximately before I went to trial that did not belong to me. So the question I would like to know is, and the answer I'm seeking is, why has not the state or anyone attempted to find out who those fingerprints belong to? I was given the fingerprint report, and I know the conclusion was that the comparison of those prints found on the car, the palm prints found on the car, and the prints found on her purse, the fingerprint report says that the comparison with my prints was negative. So that means those prints were not mine. They were not mine. Number two is, as far as the DNA, when you destroyed that DNA evidence, whenever they destroyed it, because like I said, I was given 5 different excuses when it was destroyed or how it was destroyed, but regardless of that, if it has been destroyed, then that means you have permanently suppressed evidence that could prove that that was not me, that I was not the source or the contributor of that biological evidence. You've denied me the right to do that. I need to know for certainty when and where that evidence was destroyed. Because if the evidence was never transferred from the clerk of the court over to the district clerk to be stored in the archives, then what happened to the evidence? Because of my DNA hearings, in which I had 5 of them, I got approximately 5 different excuses as to why they couldn't produce the evidence. I really would like the state to put in writing why they couldn't produce the evidence. There are a lot of questions that I think the complaining witness needs to answer. Number one, when you went to Eastwood Hospital and you said they wouldn't accept you and you went to Sierra Medical Center, why did they not accept you at Eastwood Hospital when the police report shows that the police were dispatched on this particular case to Eastwood? So somebody called the police in connection with this case. So why did you leave? When you say I initially let you go and you got in a car with 3 men that you didn't know and told them you had just been raped, and they offered to take you to the police, and an ambulance was up the street because you said that there was a body in the street in your police report, and you refused to go? Come on. If you just been sexually assaulted, going to the police and the ambulance would be the 2 main things you would want to do, especially if they're right up the street. But you decided to have them make a U-turn and drive you 95 miles back home. 3 men you don't even know. I need to know why, when you got back to El Paso, you called your boyfriend and didn't call the police. Because what did that deny me? It denied me to have the police verify that, number one, these 3 men did exist. And it denied me to get the police to get statements from those 3 men as to what they observed or what they knew. I need her to answer the question of this girl where we call her Renee. This girl Renee was staying at the house from Denver, Colorado with 5 other people. So that's 6 people, Renee and her 5 friends. You have the 3 men that gave her a ride after, that's 8 people. You got her boyfriend, which is 9. Her brother Hector, the state never called him to testify. See, that's 10. So you got all these people that she's mentioning at my trial that supposedly have knowledge of the facts and circumstances of this case. But the state never called none of them. Why is that? I need the state to tell me why these phantom witnesses were never called. I need to know this. Especially her boyfriend. He was a chief major witness, but he was never called. To this day, I don't even know his name, because she only referred to him at my trial as my boyfriend. Her brother, I later found out what his name was. She just referred to him as my brother. The girl she went to pick up, my attorney asked her, what's your girlfriend's name? Well, we call her Renee. Okay, well, what's Renee's last name? Oh, well, actually, when my brother was in Colorado, she got to stay with him. So when she come down there, we let her stay with us. So this girl, we call her Renee. Don't even know her last name. Don't even know the name of the other 5 people who was with her. See, so there's several questions that need to be answered that have not yet been answered. And like I said, the main was this, the fingerprints and the DNA and all of these things here. These things need to be answered. That gun, where did you actually get that gun from that you said I used? Where did you get it from? The fact that I went and tried and went to prison, you just sweep everything under the rug because you're satisfied that you got the conviction? There's too many questions that need to be answered. Because I know at one of my DNA hearings, I asked my attorney for them to bring the complaining witness. And I was told by the district attorney that her comment was that she wasn't coming because everything she had to say, she said in 1979. And another thing that I need the state to tell me is this. If her car was used in a crime, when the police found the car, they impounded it in the police pound. That's when they processed it and got the fingerprints off of it. But what I need to know is, 5 days later, why did you release that car when it was actual evidence? And why did you release the car not to the victim that was driving the car? Why did you release the car to the insurance company? Because the paperwork I have is the police released the car to the insurance company because the car was reported as being stolen. That's evidence. That car was evidence. It was used in a crime according to the state. So why did you release evidence? You know, I need to know why my attorney, who was ranked in the top 10 attorneys in the city, why do you didn't do your basic duty? Filing pretrial motions, making pretrial requests. I need to know what happened to all that evidence other than the fact of the 5 different excuses that they gave me. I need to know. So there's a lot of questions that need to be answered that haven't been answered. But I knew they were just happy with the fact, oh, we got a conviction, sent him to prison, so we good, case closed. Well, no, the case is still open because somebody's still out there running around and got them fingerprints. I believe I will be exonerated in the end, but because of the constraints that I have being on parole, being a felon, you know, I'm limited as to what I can do. My name is Robert Allen. I spent 30 years in prison in the state of Texas for a crime that I did not commit. My goal and my purpose at this time right now is to strive and continue to strive to get my name cleared, to be exonerated. And to do that, it requires help. And I'm just asking that somebody would just help me do what I need to do legally to just get myself cleared to where I can say, thank you. Because